Good morning. My name is Andrew Terry and I'm a corporate tax partner of Edwin Coe LLP. Edwin Coe is a long-established full-service law firm in London, founded in 1913. I've actually just joined the firm, having spent many years working in the City of London in corporate and personal tax. My last 11 and a half years were at another firm quite close geographically to Edwin Coe, where many of you will have met me over the years. Edwin Coe does the full range of legal services for clients from Russia and the CIS. These include the obvious things like property, immigration, all forms of litigation, mergers and acquisitions, and what I do, which is corporate and to a certain extent personal tax. I first went to Russia in 1995 and was very excited to do so. It was a very exciting time, and I was one of the first practitioners to introduce the concept of trusts for Russian clients and build trusts into the structures which Russian clients were just beginning to establish at that time. Things were still quite almost primitive then, but now they're become very, very sophisticated in the intervening 23 years that I've been servicing Russian and other clients from the CIS regions. I specialise, as I say, in corporate and personal international tax planning for clients from the region, and I not only act for Russian clients, I also act for clients from countries like Kazakhstan, Georgia, Kyrgyzstan, and indeed Ukraine. And a lot of the tax planning that I undertake has to do with preparing suitable structures prior to a capital raising event, such as an IPO with shares being listed on the London or the Moscow stock exchanges, a debt capital markets issue, or when a company is about to be sold, so in readiness for a trade sale. But that's not the only reason we prepare these structures. The other reasons are for good, honest, straightforward reasons to make things more efficient from a tax point of view, but also to make sure that the assets of the principal and his family are properly protected. And this involves these days a very detailed consideration of bilateral investment treaties. So we're not just looking at the tax anymore and double tax treaties. We're looking all the time at bilateral investment treaties also. The tax world's become, as most of you will be familiar with, a very complex place in recent years. It's very different from the world that I sort of grew up in back in 1985, where things were much simpler, and it was very easy to do things with structures which these days would be regarded either as nominee structures or almost as shams. So the world has moved on considerably. And this is emphasised by things like the OECD BEPS project, which takes into account transfer pricing, new control foreign companies rules, base erosion to prevent excessive interest deductions, and the artificial avoidance of permanent establishments. So what's become clear is that it's very important to demonstrate substance in a jurisdiction rather than just slot a company in, as was so frequently done between Russia and the BVI, slotting in a Cyprus company and expecting that structure to work. These days, many of those structures, as I'll explain in my talk further, won't necessarily work because the correct beneficial ownership won't lie in the hands of the owning company. So everything now has to be done on a much more thought out basis than it did before. And all these issues, as I say, I will go into during the actual conference. Just a reminder that the conference takes place in the Marriott Hotel on Tverskaya Street in Moscow on the 19th and 20th of February this year. My presentation will be given on Monday the 19th of February. It's good to meet you, and I look forward to meeting all of you in person at the conference in Moscow. Thank you very much.